Yes, good morning.
Good morning.
Yes, call, call the list.
Your Lordship, may I be
Yes,
allowed to mention a case from the list?
yes.
Yes, Your Lordship, the case listed at serial number 5, MA number 57 of 2018. Your Lordship, Pandya Neeraj Rai will assist Your Lordship in this matter. Today he is going to a personal emergency. His son is undergoing a
Serial,
medical surgery. So I pray for not today, Your Lordship.
serial number?
MA number 57 of 2018, serial number 5.
Serial number 6.
Apologies.
Uh, he's praying for time.
Yes, Your Lordship. His son is going
Is it
through a
for
treatment.
orders for? On 2015. You be there. Pandit Nirajana need not be here in this case. Yes, call the list.
From Delhi Causeway, under the heading for orders, serial number 1, MA number 98 of 16, Mr. H.K. Singh for appellant.
Sorry,
Yes,
sir.
same.
This case may be passed over for the day
Why?
because I have not gone through. I was thinking that I was responded. What is for that? If this is for the limitation,
Oh, it is coming for the first time. Notice ordinary process upon the respondents because it's two
that has been
weeks.
gone. This is for the 2 weeks. Yes, my lord.
Notice was issued, no? Notice was not issued.
Yes, yes.
Coming for
Oh,
the first
notice
time.
was good.
2 weeks, ordinary process.
Serial number 2, MA number 333 of 16, Mr. Vijay Kumar Roy
My lord, one idea has been filed for condolation of 3 days, your lordship. Only 3 days limitation is there.
Yes. Notice, ordinary process upon the respondent. Why haven't you served copies on respondent number 3 and 5? Because of
फिजिकल कर देना है मुझे.
ordinary process on respondent number 2, 2, 4. 1, 2, and 4. So far as respondent number 3 and 5 is concerned, the council will serve a copy on their respective, on the respective councils who appear on behalf of the respondent number 3 and 5.
My lord.
2 weeks requisites. Or limit.
मिस्टर जोगेंद्र प्रसाद को दे देंगे हुजूर. ये नेशनल इंश्योरेंस का हुजूर लिखा दिए.
serial number 3, MA
इसको देना
number
है आप.
My lord.
Yes.
serial number 3, MA number 237 of 17, Mr. Nikhil Ranjan for appellant, Mr. Alok Lal for respondent.
Your Lordship, I have filed an IA for taking substituted service of notice under Order 5, Rule 21 upon respondent number 2. If there is a right of recovery.
You are the
I am the claimant. Respondent number 2 is the owner, my lord.
yes, Mr. Lal.
Yes, my lord, let the notice be issued, my lord, because the paper is right of recovery has been given to us.
IA number 252 of 2022. This IA has been filed by the appellants for taking steps for service of notice upon the respondent. And in terms of Order 5, Rule 20, capital A of the CPC. It has been submitted that in spite of best effort, comma, notice could not be served in any by ordinary process or any other process upon the respondents. On respondent number 2. Thus, now his notice needs to be published in the local newspaper having wide circulation within the district of Raipur, Chhattisgarh. First up. Next, for considering the submission of, and after going through the order sheets, I find that there are sufficient grounds to allow this IA as notice couldn't be served upon upon respondent number 2 by ordinary process. Full stop. This IA is allowed. The office is directed to provide a draft to the appellants who will get the notice published in a local newspaper having wide circulation within the district of Raipur, Chhattisgarh. Stop. After publishing said notice, a copy of the newspaper should be furnished to this court along with an affidavit. He stands allowed.
Serial number 4, MA number 548 of 70, Mr. Nikhil Ranjan for appellant, Mr. Yogendra Prasad for respondent.
My lords, in the last occasion, I have taken time to seek instructions, my lords. As per instruction, my lords, the insurance company is ready to pay 1 lakh, my lords.
How much it was, Mr. Nikhil?
Your Lordship, it comes to 1,25,000. Your Lordship asked to pay 1,05,000 as lump sum compensation.
Yes, Mr. Yogendra Prasad, I said 1,05,000. Why this bargaining? If you are ready for 1 lakh, why for?
My lords, as per instruction, my lord, the insurance company is ready to pay 1 lakh, my lords.
Let them pay more now. Let them pay more. If they act too smart for 5,000 rupees, let them pay more.
हुजूर, इसको 2 और 3 कैसे हम थोड़ा इंस्ट्रक्शन फिर पूछते हैं कि आपको 1-5 करेंगे या नहीं करेंगे, मैं स्पष्ट हूं।
Yes, अभी 1-10. Now 1-10.
कि हुजूर क्वांटम पर मैं अपने से कुछ बोल नहीं सकता हुजूर।
हम आपको भी नहीं बोल रहे हैं, हम आपको नहीं बोल रहे हैं. I am telling you, I am just saying this so that you can convey the same to the insurance company. I said 1,05,000. As per my calculation, it was 1,25,000 or something. I said 1,05,000. Your company says no 1 lakh. That means this is a bargaining for 5,000 rupees by the insurance company, and I don't like this. It is trying to play with the court. Now tell them 1,10,000. They are ready, or otherwise I will pass an order. Pass over 2 or 3 cases, Mr. Prashad.
My lords.
Just your work is only to convey. Your work is nothing. It is nothing upon.
Yes, my lords.
And Mr. Prasad, in these type of cases, not only you, I tell all the insurance company, just tell them to open the link and see the proceedings, so that nothing comes upon the lawyer. कि भाई हम ऐसा नहीं बोले आप. So nothing comes upon you.
Yes, my
Give them
lords.
and YouTube tell them to open and see the live proceedings, so that they will also know.
My lords.
After 2 or 3 cases.
Hello.
Serial number 5, MA number 37 of 80, Mr. DC Jha for appellant, Mr. Om Prakash Tiwari for respondent.
Lord, my lord, the order has been passed on 31st of 8, 2017, my lord, and intentionally this appeal has been preferred in the High Court and has been kept pending for a long time, my lord. I am appearing on behalf of the respondent number 1, the deceased wife, my lord, and the deceased wife have got 2 unmarried daughters, my lord, just who was totally fully dependent upon the deceased husband, my lord, who died in the accident, my lord.
Yes, Mr. Jha, what is the ground for your appeal? Yes, Mr. GC Jha. Where is Mr. GC Jha? Unmute yourself. There's some problem with your
There is some problem
audio system. There's a problem with your audio system.
with the link. It was wrong with the audio. He was there.
Unmute करिए sir.
आवाज आ रही है? Am I audible?
Yes, you are audible.
Yes, Lord. Lordship, in earlier Lordship notices has been issued upon respondent 1, 4, 5 and 6. 1, 4 and 5 are the family members. Your
Why
Lordship.
have you filed this appeal?
Lordship, it is an accident between two vehicles, Your Lordship.
Okay.
Two vehicles.
Good.
And it is true that in this case, right to recovery has been given to the insurance company. But when the case was filed earlier, Your Lordship, there were some decisions that insurance company cannot be directly asked to deposit, and right to recovery has come thereafter, Your Lordship. In that circumstance, it might have been filed.
What do you want?
Lordship, next week रख दिया जाए, next week आज का दिन रख दिया जाए, I will take instruction from them. When right to recovery has been given, driving license was not there, that is the maximum we can get, Your Lordship. But at that time,
even if the driving license was not valid and not having, but the award cannot be denied on the ground of.
no, it's all right. That, I am not disputing this fact, Your Lordship. But when it was
This is a case of composite negligence.
yes, Lordship. A trailer and a car met with an accident, Your Lordship.
Trailer and a car. It is the trailer who was. It is the offending trailer.
No, it has been come that the car was offending because trailer was standing, car has dashed from the back.
Okay.
So let this case be on next week, Your Lordship. Today,
On the request of Mr. Jha, this case is adjourned for 1 week. Is this case next week? This case is
Yes.
adjourned.
आज ही के दिन आज के ही दिन रख दिया जाए, एक वीक रहेगा.
Serial number 6, MN number 57 of 80, Mr. Pandey Neeraj for appearance, Mr. Nayari for respondent.
Yes, Mr. Iqbal.
Yes, I am for the respondent, my lord.
Respondent number?
Respondent number 1, my lord.
It's a probate case.
Yes, my lord.
There's a delay of how many days?
56 days, Your Lordship.
56 days. I'm condoning it. There's a delay of 56 days. The grounds have been sufficiently stored. The medical certificates have been annexed. Delay condoned. In this case, I'm waiting for admission.
Deeply obliged, Your Lordship.
What is your name?
Pradyumna Poddar.
Heard Mr. Pradeep Mekodar on behalf of that.
Serial number 7, MA number 70 of 80, Mr. Vikas Sinha for appellant, Mr. Alok Lal for respondent.
So this is the last order may kindly be seen. Order dated 2/8/21.
2821.
21. We have paid the entire amount.
Just a
Yes. The amount in terms of award, the appeal was filed for enhancement.
No, it was not
The-
filed for enhancement. It was filed for some other reason. Amendment was made. That amendment was allowed.
Yes, yes. And now therefore it's an appeal for enhancement. But the claimant has, well, subsequently murdered. The father-in-law is also died.
That is why order dated.
Yes,
Claimant
yes. The claimant widow was murdered. The father-in-law has also died. And now, my lords, on last date, I have said that the
2881 order may kindly be seen. That will clarify the position. How this can be stretched to that extent.
Where is Vibhash Sinha?
Yes, my lords.
Now, the awarded amount has been paid.
Awarded amount was paid.
It was apportioned.
Yes.
It was apportioned. Claimant received that amount.
Both
And
the
she was,
father-in-law and the wife, both the father and the wife received the amount.
yes.
Now, this was for enhancement.
Appeal was, my lords, was for enhancement.
Now what will happen?
But it's the only thing is that since I am not able to trace out the legal heirs of the deceased,
Both the PLV also, the Jalsa is also not being able to trace out.
so that is the difficulty. Then my lords may record my statement and
Now,
maybe
question is,
dismiss the default.
now the question is, if you enhance the property, now who will receive that enhanced amount? It will be a lottery for that
Nobody is,
person.
no,
It will be a
there is
lottery
no
for
one.
that person.
Yes.
It will be a lottery for that person. So,
Initially, the appeal was for apportionment, proper apportionment. Thereafter, some suggestions came. Then the amendment application was filed, which was opposed. Then amendment was allowed. It was initially, kindly see the original prayer of the claimant. It was for apportionment only.
Seema Kumari is dead.
Yes.
Yes. And her father-in-law was also dead.
When did Seema Kumari die? Any?
But after receiving amount, I exact date I also don't know for the reason because through paper I came to know that she was murdered.
In the year 2000?
But it's the amount I think 2020 end or 21 starting, my lords. Probably 20 itself.
It has been. Submitted. That sometime in the year 2020, most probably sometime in the year 2020, the sole appellant has expired. Next time. Expired. There is no petition for substitution on record. Next time. Considering the fact that there is no petition for substitution, and today we are in 2022 April, this appeal stands abated.
My lords may also record that despite my best effort, I could not contact any of the legal counsel, legal heirs. The para legal heirs also could
When
not.
Jalsa could not contact, who are you?
The report of the report of Jharkhand has already there is the report of Jalsa which suggests that the legal heirs, if any, of the deceased is not traceable.
But if it is simply abated, then this will always show pending. This will always indicate appeal pending.
How?
As once appeal abated, then the appeal has come.
This is finished. This is sole appellant.
Yes.
If there are other appellants, then it will show pending against the others. It's the sole appellant. Since the appeal itself is, since the appeal itself has abated, no order in the IN needs to be passed.
Serial number 8.
Advertisement.
Mr. Manish Kumar for appellant, Mr. Nitin Ranjan, Mr. Ashutosh Anand for respondent.
May it please your lordship, my lords. In this case, notices were issued, my lords, for against respondent number 3 and 4, who are the parents. Though they were before the learned tribunal, my lord, the direction has been to make payment only in the name of claimant number 1, who is wife of deceased. They have been treated as to be dependents, my lords, and 1/4 was deducted by taking
No,
them
no,
also
no. Just
dependents.
a minute. The respondent number 1 is the wife of the deceased.
Yes, my lords.
Respondent number 2 is the daughter of the deceased.
My lords.
And 3 and 4?
Parents. They have been treated to be dependents, and while deducting my lord's expenses towards personal expenses, 1/4 has been deducted by taking them as dependents.
Okay.
Notices were issued to them, but perhaps they have not appeared.
No. What is the ground of your appeal?
Appeal is, my lords, twofold, my lords. One is contributory negligence, and second is that the place of occurrence is a private garage of an apartment, which does not come under the public place. And third ground is also there, my lord, that he was a contractual employee. He was working in a project in Birsa Agricultural University. He was not a permanent employee. So 40% future prospects should not have been given. These are the grounds of appeal, my lords. And surprisingly, the tribunal has directed payment of entire compensation in the name of claimant number 1 and directed to deposit some amount in the name of the daughter, claimant number 2. But has, my lords, neglected or failed to grant any amount to the parents.
1 and 2 has appeared.
Yes, Mr. Nikhil Ranjan has appeared, perhaps.
Yes, I'm appearing for payment.
Where are 3 and 4, Mr. Nikhil Ranjan? Where are respondent number 3 and 4?
By the order dated 22nd March, also he was directed, 22nd March 2021.
Lord, I sought instruction, but वकालतनामा मिलोड इसमें एक 1 week का एक और time दे दिया जाए मिलोड. I'll ask because last time I contacted them, I could not contact the claimant. So who's the wife?
By way of one indulgence, further 2 weeks' time is granted to Mr. Nikhil Ranjan to seek instructions from the respondent number 1. In respondent number 1. Necessary instructions.
My lord.
Serial number 9, MN number 127 of 18, Mr. Manish Kumar, for appellate, Mr. Anil Kumar Ganju, Mr. Sarvendra Kumar, Priya Kumari for respondent.
My lords, this case notices were issued, my lords, but there is no limitation why it is listed. I am not aware, my lords, under the heading for orders. Notices were issued, my lords, on 14/2/2019.
Notice received to 1 to served upon 1 to 8. 1, 5, 6, 7, 8 appear through Wakalatnama.
Your Honor, I am appearing on behalf of respondent number 1 to 6.
All?
No, sir. Respondent number 1 to 6.
On the 1 to 6 you are appearing.
Yes, sir.
So and so appears on behalf of respondent number 1, 2, 3, 4, 5, 6. Good stuff. Who is for 7? 7, 8. What is the notice?
Name of several lawyers are appearing in the cause list, my lords. I am not aware.
What is 7, 8? What about 8? 7, 8. Who is 7?
7, there are 2 vehicles involved, my lord. 7 is owner of truck.
What is the name of 7?
My lords, name of 7 is, my lords, Ramu Naidu.
He is Pradeep Kumar.
may I submit one thing, my lords?
Again,
The
so far as this
quantum,
respondent number 8,
quantum.
this has been validly served as he has received the notice.
8 is Pradeep Kumar.
Valid served service. Where is Raman Naidu? It has also appeared. Validity has appeared. 1 to 6 and 8 appear through Wakalatnama. What is where is 7? SR not received. 8, 7 SR not received.
I have no grievance against him, my lords. It is, our case is only two grounds are there, my lords. One is contributory negligence. The tempo was uninsured. He has appeared. Respondent number 8, my lords. And quantum, and they have appeared, my lords.
Okay. In view of the relief which has been claimed in this appeal.
Your Lordship, my very short submission on behalf of the respondent is that the truck was there in FIR and there is no question of a contributory negligence as the tempo was not charge sheeted.
Just a minute. There is a- as the counsel for the appellant submits that he has not sought any relief against respondent number 7, comma, no fresh notice be issued to respondent number 7. Full stop. Is this case under the heading for admission?
Right. Obliged.
Obliged.
Serial number 10 with serial number 11, MI number 152 of 18, with cross objection 6 of 21, Mr. Amresh Kumar for appellant in first case, Mr. Arvind Kumar for appellant in second case.
My lord.
On behalf of the appellant, Your Lordship, notices has been issued on 18/5/2018, Your Lordship. The respondent has appeared, but respondent number 4 has appeared or not appeared, Your Lordship. I don't know. 4 is the owner of the scooty, Your Lordship. And one IA application filed by the respondent, Your Lordship, claimant that claimant number 2, at least the respondent number 2 died. So maybe deleted the name of the respondent number 2. Or 1 week time may be granted me, so I file the petition.
Going to file proper application as it has been informed that one of the respondents is dead.
My lord.
Proper application.
Yes,
The
yes.
appellant submits that he wants to file an application deleting the name of respondent number 2. Full stop. Comma as he is dead. Full stop. They are allowed. Is this case after 1 week? Yes, Mr. Yogendra Prasad.
My lord, item number 12.
Where is Mr. Yogendra Prasad? He was here. Okay, item number 12.
Serial number 12, MI number 154 of 18, Mr. Amresh Kumar for appellant, Mr. Subodh Kumar Dubey, Mr. Mukesh Kumar Dubey for respondent.
Your Lordship, in this appeal, Your Lordship, notices has been issued earlier, Your Lordship, and limitation of only 6 days, Your Lordship.
No, Mr. Mukesh is appearing on whose behalf?
I for respondent number 4, my lord.
4 is the
Owner of the vehicle, motorcycle. Claimants are 1, 2, and 3.
So what is your ground, Mr. Amresh Kumar?
Your Lordship, is a personal accident, and the disease was not the owner, Your Lordship.
Not the owner
of the vehicle, Your Lordship.
Then how the
It's a
accident?
hit and run case, Your Lordship.
It's a hit and run case.
Yes.
IA number so and so 6 days delay after going through paragraph number so and so the 6 days delay is controlled. This is for example the heading for admission.
Oblige.
Serial number 13, serial number 14, serial number 15, ME number 196 of 18, ME number 484 of 15, ME number 483 of 15, Mr. Mohammed Asadullah, for appealing 4 days, Mr. BC Ghosh, for appealing second, third day.
मैं प्यार में मार से मैंने आइटम नंबर 14 मैंने वक्त में फाइल मैंने within 2 weeks time I'll grant मैंने आइटम नंबर 14 respondent number
Item number 14 will okay. On the request of Mr. Asadullah, this case is adjourned for 2 weeks. Sir, adjourned.
ये वाला पढ़ लिया बहुत मजेदार केस
Yes, Mr. Yogendra Prasad.
Yes, my lords. I have conveyed the views of my lord as well as I persuade them accordingly. Now they are ready, my lords. For my lords, as your lordship, please, my lords.
110. Yes, who is appearing?
My lord, I am appearing for the claimant.
What case serial number?
Serial number 3, my lord. 4.
Serial number?
4.
4.
Serial number 4.
The counsel appearing on behalf of the claimants submitted that if an additional amount of rupees 1,10,000 lump sum is paid, his client will be satisfied with the aforesaid amount and will not pursue this appeal. Also, next para. Mr. Yogendra Prasad, after seeking instruction from his client, submits that insurance company is agreeable to such additional payment. First of considering the said submission, let this matter be referred to the National Lok Adalat on 14th of May.
Oblige, my lord.
Serial number 16 is wrongly listed. Serial number 17, MA number 225 of 80, Mr. M. B. Lal, for appellant, Mr. Manish Kumar, Mr. M. K. Roy, Mr. Yogendra Prasad for
Yes, Mr. Karan.
My lord, this is an injury case, my lord.
Okay.
And the notices has been issued, but I am not aware whether any learned counsel appeared for on behalf of the vehicle, owner of the vehicle.
My lords, in this case, I am appearing for National Insurance Respondent number 2, my lords.
Right to insure, right to recovery.
Right of recovery is there, my lords.
Where is the owner? Owner is respondent number 1. Respondent number 1 has appeared through Wakalatnama. Who is for respondent number 1? Yogendra Prasad is for the insurance company. Where is Mrinal Gandhi Roy? His name is appearing? Yes. Mr. Yogendra Prasad appears on behalf of. Yes, Mr. Roy. There's a delay. I am condoning the delay. Unmute yourself. Mr. Roy, Mrinal Gandhi Roy, unmute yourself.
My lord. My lord, am I audible now, my lord?
Yes. 20 days delay. I am condoning the delay.
Yes, my lord, that may be condoned, my lord.
Heard Mr. Yogendra Prasad appearing on behalf of the insurance company and Mrinal Kanti Roy appearing on behalf of the owner of the vehicle. Full stop. Next para. The learned counsel for the appellant submits that there is 20 days delay and there are good grounds to condone the delay which has been mentioned in paragraph so and so so and so. Next para. After considering the IA application, I find that good grounds are there to condone the delay. Delay condoned in this case under the need for admission.
Obliged, my lord.
Obliged, my lord. Sorry, my lord, I was delayed by due to some problem, my lord, technical snag.
Yes.
Serial number 18, MA number 227 of 18, Mr. PC Sinha for appellant.
Yes, Mr. Sinha, Prabhas Sinha, where are you? Where is Mr. Prabhas Sinha? No one appears on behalf of the appellants. Pass over, preparation. Pass over.
Serial number 19, first appeal 233 of 18, Mr. Mukesh Kumar for appellant, Mr. Sameer Akhtar, Mr. Yogesh Modi, Mr. Praveen Bhai for respondent.
Your Lordship, I am appearing on behalf of the state, Your Lordship, in this case, Your Lordship. I pray for 2 weeks' time, Your Lordship, because senior has to argue this matter, Your Lordship,
What is
and he is
matter?
not.
My lord, this matter is in respect of the first appeal under section 54 of the Land Acquisition Act, and your lordship has by order dated 14th of August, your lordship has pleased to admit it, and LCR has been called for, and notices were issued to the private respondents. I have filed an IA 6926 of 2021 for having a stay of the order, my lord, because they are executing this order, and your lordship, while admitting this, your lordship has also called for the record. And if they will withdraw the money, it will highly prejudice to me, my lord.
Who are you?
I am the awardee. The award is in my favor. And the opposite party respondent has filed a petition under section 18 and 30. This is peculiar, my lord. The composite petition has been filed and the court has modified the award and they have apportioned the award. And therefore, the lordship by 14th of August, the lordship has admitted it. LCR has been called for. Notices were issued to the private respondent. They perhaps appeared.
So you claim that the entire compensation amount should be paid to you.
No, entire no. It is only 3 decimal ka hai, 55 lakhs ka hai, wo hai. For that, because the award, the state has, my lord, peculiar fact is that the lordship is aware, section 18 और 30 दोनों में कलेक्टर को पावर है रेफर करने के लिए, और कलेक्टर 30 में रेफर कर रहे हैं, कंपोजिट एप्लीकेशन 18 और 30 में फाइल होता है, and court has modified the award. They have apportioned the award. That is not the mandate of the act. सेक्शन 18 में होता है ये इंटरेस्टेड पार्टी को. आई कैन रीड विथ योर लॉर्डशिप परमिशन सेक्शन 18. देयर इज अ वास्ट डिफरेंस बिटवीन सेक्शन 18 and 30. And if the interested person is there, the third person, Mr. Anil Kumar Singh, who has been inserted by the court, कि इनको अवार्ड मिलना चाहिए. He has not filed any petition before the court, either in section 18 or 30. His brother has filed a petition, and that too without adding him as a party. But after all, award is in my favor. Now they say the award should be paid to Mr. Anil Kumar, who is neither the party in the court. So this is for that purpose. I have only filed this IA for having a stay because it is a money decree. They will withdraw the money. The court has refused my prayer for a stay, and they are proceeding with the execution case. Even though I have pleaded before the court that interlocutory application is filed, appeal has been admitted, but the one line they said without having a stay, there is no stay in this order
Where
because
is
it
your
is.
stay petition? Yes, you want to file an IA to the stay petition? Rejoinder?
Yes, my lords. I am for the opposite party, my lords.
Mr. Jogesh will be
Respondents.
appearing on behalf of the contesting respondent. Submits that he wants to file a rejoinder to the stay application filed by the appellants. How much time?
2 weeks, my lord.
As brief,
This
2 weeks time
IA was filed in 2021.
2 weeks time is granted to file to the parties to file any rejoinder if any. So stop next para. Uh, till the next date of listing, the no amount should be disbursed to any of the parties. No amount pursuant to the award should be disbursed to any of the parties. Award passed in so.
Decree under
credit report below has
decree
prima
under
facie,
appeal कर
lords.
दीजिए.
This case after 2 weeks.
मतलब डिक्री अंडर अपील कर दीजिए क्यों अवार्ड तो सब आदमी का था डिक्री अंडर
Degree under appeal.
आई एम ग्रेटफुल योर लॉर्डशिप
In case number so and so. Yes, next.
case number is my lord exclusion case number 94 of 19.
लिखे तो no amount should be disbursed. No amount. No, it's not. It will not be the execution case. No amount pursuant to the order passed in case number so and so should be disbursed.
In pursuant to the execution case, your lordship may mention.
No. Why execution case?
ठीक है my lord.
It's for execution. I am saying pursuant to the decree.
That will suffice, my lord. Grateful, yes. Obliged, your lordship.
Obliged.
Serial number 20, MA number 241 of 80, Mr. Ayush Aditya, Mr. Abhishek Piyush, Mr. Munna Kumar for appellant.
Lord, there is an IA for substitution, lords.
Who is there?
IA number 3244. Lord, there is delay, lords.
Who is
substitution
there?
of respondent number 6. Respondent 6.
Yes. IA number 3244 of 2021. It has been mentioned that respondent number 6, Ram Pravesh Sahu, died on 12/12/2020. During pendency of this appeal, leaving behind so and so, paragraph 2. First up, the counsel for the appellant submits that since right to sue survives, the heirs of respondent number 6 needs to be substituted. Yes, this is in time.
No, Lord, not within time, Lord.
How?
Lord, 12/12/2020, and has been filed on 13/7/2021, Lord, after 90 days.
What about the Supreme Court order extending?
Yes, but that Supreme Court order, therefore, Lord, that said that due to pandemic, Lord, I mentioned in the petition also.
In view of the order passed by the Honorable Supreme Court extending the period of limitation in cases, during pandemic, this IA is deemed to have been filed within the time. Full stop. Considering the aforesaid facts, this IA is allowed. Let name of respondent number 6 be struck off, and in his place the name of so and so be substituted. Full stop. The applicant should make necessary correction in the cause title in Reading within 2 weeks. Is this case under the name for admission? What is this?
Lord, this is an appeal, my lords, against order 39 rule 1 and 2, my lords. Injunction was rejected.
43 rule 1R. 1R.
Yes, Lord. Yes, Lord.
Injunction rejected.
Yes. Lord, the suit was for declaration of right title interest, Lord. In that, Lord, the injunction application was filed, restraining them from making construction. Although the other side have specifically stated that they are not making any construction, and have denied that they are not about to make any construction.
What is the status of the suit?
But the suit is pending, notes. I've just inquired from my client, the suit is pending.
What stage?
But that note I'm not aware, notes.
Call from a report of the call for a report from the principal district judge Gumla about the status of the original suit number 8 of 2013 pending in the court of Civil Judge Senior Division 1. Full stop. A detailed report should be sent which should indicate the date when the parties appeared, the date when the written statement was filed, the date when the party respondent has appeared, date, date when the written statement was filed, the date of framing of issues, and if the statement of the witnesses are being recorded, the dates, respective dates. There's this case after 2 weeks under the heading for admission along with the said report. Get a copy of this order to the court concerned.
Obliged.
Serial number 21, MA number 268 of 18, PCC number appellant, Mr. Ashutosh Anand for respondent.
As Lordship, I am appearing for the appellants. This is for the enhancement, Lordship. Notice was issued to the company and the driver owner. Company has appeared, but driver owner has not appeared.
Right to recovery granted?
My lord. Yes, Lordship. He says that the driver has no driving license. That's why it has been given. It is for the enhancement, Lordship. I have been given only Lordship 5,23,600. Although he was 25 years old, unmarried, and he was a mason, these claimants are the parents.
But where is the owner of the vehicle?
Not appeared, Lordship. Notice was issued.
Even in the lower court also they did not
Lower
appear.
court not appeared. Not appeared.
One. What is the name?
Mahendra Jadhav is the owner, and Lalu Thakur is the Lordship driver. They are resident of the same locality, Lordship. No, one is from Bardhaman, Lordship, and the second driver is from the Greedy at Rajanwad. I don't know whether notice was validly served or not, Lordship.
No such person living in that area.
Whatever address has been given, Lordship, on that address, as I have made party.
From where did you get this address? From where did you get this address? You are the claimants.
This address is from the impugn order, Lordship.
I'm asking you the claimant. Before the impugn order, there is a claim application. From where did you get this address which you had put in the claim application?
I simply made party, Lordship, because the address was given in the impugn order.
And I'm not asking Prabhas Sinha. I'm asking the claimant. From where did the claimant got this address?
Lordship, that I am saying, Lordship, I can't say from where they get this address, Lordship. I have to verify, Lordship, then from where he get this
Should furnish
address,
the
Lordship.
present address, present current correct address of the owner of the vehicle, offending vehicle.
It may be simply, Lordship, adjourned for 2 weeks. I will verify, Lordship, and if it requires the changes, I will change,
For
Lordship.
4 weeks.
Lord.
4 weeks.
Lord. Lordship, in serial number 18, I could not appear, Lordship.
Yes, what is serial number 18?
Sirajul Ansari, Lordship.
18.
In this case, company has also not appeared, Lordship.
18. What is this case? 18 is password. 18 password, yes. 18 was why it has been listed 18. Fresh notice on respondent number 1 and 2, present and correct address requisites 3 weeks. Ordinary process.
Under the heading for admission, serial number 22, MA number 288 of 50, Mr. Vijay Kumar Sharma for applicant, Mr. DC Shah, Mr. Kishore Kumar Singh for respondent.
May I please, Your Lordship?
Yes.
The instant memo appeal has been filed by the claimant's appellant for enhancement, Your Lordship. In the case of the injury case, Your Lordship, 40% permanent disability, Your Lordship. And in the course of the hearing, the claimant was died, Your Lordship. Then the substituted here of the mother and the wife has made the party in this appeal, Your Lordship.
Mother,
And the
mother is
legislative
the
mother and mother, Your Lordship, mother has filed the appeal before this honorable court, Your Lordship. And the wife is the respondent number 4, Your Lordship. In this case.
who appears for the wife?
Your
Who
Lordship,
appears for the wife?
notice was
Okay, last occasion notices were issued on 22 February 22. Notices upon respondent 4, wife.
and notice was validly served, Your Lordship.
You are the mother.
Lordship.
Where is the father? Father is alive.
Mother is alive, Lordship.
I'm asking whether the father is alive or not.
I am not aware, Your Lordship, perhaps.
Lordship, which is an injury case. Injured during the course of trial, he died. Thereafter, wife and mother have been implicated as a party.
LCR is here. Call for the lower court records.
Lordship.
Serial number 24,
Yes, next.
number 422, Mr. Jharkhand for appellant, Mr. Udayan Thakur, Mr. Dalisur Rahman for respondent.
Lordship. Lordship, I'm appearing for the appellant.
Yes. What is your ground?
The main issue in this is with respect to the permit, Lordship, and the right to recovery has been provided, Lordship.
Right to recovery provided to you.
Yes.
Why have
We
you
have to
come in this appeal?
The permit is not there, Lordship, which is essential as
That is why the right to recovery was granted. Let us see what are the grounds.
the permit is not there, Lordship, which is there in paragraph 15 as well as also in paragraph 23, Lordship. It has been admitted that permit was not there as per according to section 66 of the Act, Lordship, which is mandatory.
Okay, the counsel for the I am dismissing it.
Lordship, I may be permitted to take opinion from the company that what is their opinion with
I am
respect to the
dismissing.
payment
I am dismissing it.
and
My
recovery.
dismissal will not depend upon your company's advice. Okay.
Yeah,
Heard the counsel for listen to the order. Heard the counsel for the appellants
because it is admitted, Lordship.
appearing on behalf of the insurance company. First, the next one. The insurance company has preferred this appeal challenging the award dated 18th February 2015, passed by Principal District Judge cum MACT, Godda, entitled Motorbike Suit number 45 of 2012, whereby an amount of compensation has been fixed to the tune of rupees 6 lakhs rupees. How much?
6,05,000, Lordship.
Who is for the claimant?
Wife, Lordship. Wife and children.
Who is for the claimant? Who is appealing for the claimants?
Lordship,
He has died, I think so, Lordship. Last time you had to send it to the legal service, but
Who has died?
Mr. Udayakant Thakur, Lordship, is the
Lordship.
Oh,
advocate
they
of
Yes, Lordship. Yes, Lordship.
there
That's
is
the
one.
matter.
There is one ground, madam. Under conventional aid, 1,25,000 has been paid, but but just a minute.
My Lord may read paragraph 23, which states very clearly and has been admitted that the permit was not there.
What was the age of the deceased?
57 years, Lordship. And he was a laborer earning 250 rupees per day. They have calculated it to 7,500.
Into 12, one third. $60,000 per annum. 284 lakh 80
The amount has also been enhanced, Lordship.
lakh 80 plus what you pay. Alikida? Okay. Uh, I've heard the concept of that. Against the award dated so and so. Full stop. The learned counsel submitted that since admittedly there was no permit of the offending vehicle, comma, the owner should have been made liable to pay the entire amount of compensation. She submits that the tribunal in paragraph
Lordship. Paragraph 23, 21, 22, and 23, issue number 6 and 7.
para number 23 had
Yes, Lordship. Whether
categorically
it has been held.
arrived at a finding that the owner of the vehicle had no valid road permits. Thus, there was a violation of the terms and condition of the insurance policy. Full stop. As per her submission, since there was concrete finding arrived at by the tribunal that the owner has violated the terms and condition of the policy, then it should have been it should have been the tribunal should have directed the owner to pay the entire amount of compensation. First, further, the counsel for the appellant submits that in view of the judgment of the Honorable Supreme Court in the case of Pranay Shetty and others, the claimants are entitled to receive rupees 70,000 under the conventional head, whereas in the instant case 1,25,000 has been met, which needs to be paid. Thus, there should be reduction in the amount of compensation, the quantum of compensation. Next part. Now, first up, these are the only 2 points raised by the insurance company. Next part. Since the grounds are limited and considering the nature of the ground, it is not necessary to LCRI call for the lower court records, as the findings arrived at in the and as reflected in the award is sufficient to decide this appeal. Next one. It is admitted the offending vehicle is registered as J817D0979. First up, the tribunal has concluded that there was no road permit of the vehicle, which is an auto rickshaw. First up, the fact that the vehicle was insured with the appellant is also admitted. First up, when I go through the impugned award, after going through the impugned award, I find that in paragraph 23, the tribunal has categorically given a finding that owner of the vehicle had no valid road permit. Thus, there was violation of terms and conditions of the policy. First up, the tribunal further held that in view of the tribunal, after considering the judgment of the Honorable Supreme Court, has held that in these cases, in these type of cases, the insurance company should pay the compensation to the claimant and would recover the same from the owner. In the order, the tribunal thus ordered and has granted right to recover the amount of compensation from the owner of the vehicle. First, I find no illegality. There is no illegality. Thus, there is no illegality. There is no illegality committed by the tribunal passing the aforesaid order. First, since the right of recovery has already been granted to the insurance company, the aforesaid the ground taken by the insurance company that the owner should have been directed to pay the amount fails. Fails. Next. So far as the second ground is concerned, I find that the tribunal has awarded 1,25,000 on account of under the head of loss of love and care and funeral expenses. First time. In terms of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others, the under conventional head, rupees 70,000 has been held to be the appropriate amount. Thus, so, thus, 55,000 excess have been awarded by the tribunal. Next. While holding so, this court also takes note of the fact that the tribunal has not awarded any amount on account of future prospect under the head of future prospects. Also, the Honorable Supreme Court in the case of Pranay Shetty and others had held held that deceased while awarding compensation, comma, the amount at a particular fixed at a particular rate has to be paid, has to be awarded under the head of future prospect. In the instant case, the deceased was aged less than 60 years. It was in the age group of 51 to 60. Thus, 10% enhancement should have been awarded. But the tribunal has not awarded any amount under the head of future prospect. So, if the future prospect was granted, the excess payment which has been made on account of under the head of conventional head would have been set off. Next one. Considering what has been held above, I find no merit in this appeal. Full stop. This appeal is dismissed. Stop. The insurance company will be at liberty to recover the amount from the owner of the vehicle.
My lord, I appear for vehicle owner, my lord. Respondent number 4.
Yes.
My appearance may be.
Yes. For the vehicle, owner of the vehicle, and he submits that he has not challenged this award.
Serial number 24, number 95 of 16, Mr. Indrajit Sinha, Mr. Suraj Singh, or appellant, Mr. Nikhil Ranjan, for respondent.
Lord, I pray for the short Passover.
Serial number 25, MA number 396 of 16, Mr. M. Lal, for appellant,
Yes, Mr. Karan.
My lord, I am appearing, my lord. My lord, the present appeal is for enhancement of compensation, my lord. The deceased was having a business of selling chow mein, eggs, meat shop, etc. And his earning was 9,000 per month. However, the claim petition was filed under section 163A, my lord. And as per the structured formula, a second schedule of ABA, the tribunal has assessed the income of the deceased was 15,000 per annum, and deducting 1/3, 9,000 multiplied by 16 below, as per the structured formula, serial number 6 of the formula below. My contention is that, Milord, that his earning was not considered, and moreover, the learned court has, in its finding, has decided that deceased was not doing any business or not doing anything prior to his death, Milord. The PW1 mother of the deceased has deposed that her son was doing business of fast food on Thela. Uh, Father of the deceased has also deposed the same. However, in the cross, he deposed that his son was working as loader. He used to load articles on tractor or trucks. So, on the basis of this,
So what was the minimum wages at that point of time?
Milord,
What was the minimum wages? Where is the owner of the vehicle? The right to recovery has been granted.
yes, Milord.
Where are the owner of the vehicle?
Some persons are appearing, my lord, but in this case, I would like to submit one thing. At the very outset, whether this appeal for enhancement is maintainable because, as per the law states and interpreted by the Honorable Supreme Court, under the structured formula, the annual income is the ceiling is there only 40,000. Beyond that, it goes outside the purview of the 130 163A. There were some judgments of the Honorable Supreme Court, our own High Court, and other High Courts also.
Now, whether this structured formula could have been applied in this case, tell me. Just
No,
because the
but
payments
in
are
that
failed,
no. But if the claim is under 163A,
just because the claimant, the lawyer of the claimant has filed this by branding it to be 163A.
whatever it may be, the law is very clear. Law is very clear in this case. There are two judgments of the one judgment of our own High Court and one of Honorable Supreme Court. If my
Yes,
Lord will permit, I will rely upon those judgments.
yes, definitely.
So first in
163A.
this case would be the first in this series would be the Honorable Supreme Court judgment reported in AIR 2004 Supreme Court 2107.
AIR, AIR
Supreme Court 2004 Supreme Court 2107.
0, AIR 2004
2167.
2167.
7. Justice B.N. Khare, Justice
20
Nalini Sinha, and Justice
21
Padia.
2167. 2167.
2167. And in that case, the paragraph 67 would be the relevant.
Yes.
I'm going to the head note first, then I'll go to the paragraph 67. Just little further, I'll go for 66 first.
This was an application under 163A.
Yes, 163A. There are other cases also. There is recent one is of 2017 TAC of Mama. I'm reading paragraph 66. We may notice that section 167 of the Act provides that where a death of the or the bodily injuries to any person gives rise to a claim, compensation is under the Act, and also under Workmen's Compensation Act, he cannot claim compensation under both acts. The Motor Vehicle Act contains different expression. For example, under the provisions of the Act, provisions of this Act, under any other provisions of the Act, any or any other law otherwise in section 163A, the expression notwithstanding anything contained in this Act or any other law for the time being in force has been used, which goes to show that the Parliament intended to insert non-obstinate clause for a wide nature in which would mean that provision of section 163A would apply despite the contrary provision existing in the Act or any other law for the time being in force. Section 163 of the Act covers cases where even negligence is on the part of the victim. It is by way of exception to 166, and the concept of social justice has been duly taken care of. Now, paragraph 67, we therefore are of the opinion that Kodla Supra has correctly been decided. However, we do not agree with the finding of the Kodla Supra if that a person makes invoke section 163A, the annual income of rupees 40,000 per shall be treated as a cap. In our opinion, proceeding under section 163 being a social security provision, providing for same would only for those whose annual income is rupees 40,000 can take the benefit All other claims are required to be determined by the in the chapter section chapter 11 of the Act. So this is the one. This is the first one. And other one, our own High Court, that is reported in JLJR 2004 Volume 4. The JLJR and the citation would be 2004 Volume 4 JLJR page number 728. In this case also, Your Lordship, the paragraph 17 would be very relevant. I'll be reading the paragraph 17.
Yes.
Recently, in a case of Deeplal, Girish Bhai, Soni and others, United India Insurance Company Limited, 2004, AIR 2004, Supreme Court 2107, the which I have referred. The citation perhaps is here wrongly written. While considering the provisions of Section 163A of the Act, second schedule, their Lordship of the Honorable Supreme Court, after considering the earlier decision, has finally held that since the provision of Section 163A being a social security provision, the benefit of which is available only to those whose annual income is rupees 40,000, and all other claims are required to be determined under Section Chapter 11 of the 12 of the Act. We therefore that quotation of the judge, this is there, but now the finding of this honorable court, coming back to the instant case, it has not been disputed the claimant. The claim application was filed under 166A of the Motor Vehicle Act 1988 was the grant of compensation and not under 163A. And the act, which was also evident from the impugned judgment, shows that the tribunal decided the claim application of the claimant under 166A of the act. In my opinion, therefore, instead, the tribunal ought to have assessed the compensation on the basis of guidelines provided under clause 6 of the second schedule of the Act, which applies to such cases. The claim application filed under section 163A. Otherwise, the claim application can be considered under section 163A clause 6B of the Act, where the annual income of the claimant is up to 40,000 held by the Supreme Court in Girish by Sony United Insurance Company Limited. Now, subsequently, one of the latest one which I could get is the 2017 Volume 2 TAC. Latest which I can get it is this one.
No.
Of course, this is from a different honorable High Court. This is Himachal Pradesh.
The annual income cannot be more than
40,000.
No, here the annual income
Here
is
they are
only
claiming 90,000.
The annual income is only 15,000.
No, they are claiming 9,000 monthly income. So if it is multiplied by 12, how much it will become? If it is multiplied by 12, this will come to more than 40,000. Therefore,
so if it is 3,000, if it is 3,000,
of course, 3,000, 36,000 in that case, I will have nothing to say.
What will be the amount of compensation then?
Thus, if it is taken 3,000, then I have nothing to say.
15,000 means how much? Per month it will be less, it will be just more than 1,000 rupees. Where are the owners? Owners of the vehicle?
But perhaps for all insurance company, Mr. Roy appears.
Yes. You both are appearing on behalf of the insurance company. But where is the owner of the vehicle?
Yes.
Milord, there were two motorcycles involved in this accident, Milord. And
Yes.
owner of one of the motorcycle, they have earlier appeared, Milord. And another motorcycle owner of the motorcycle was not appeared.
Then they have not filed any appeal.
No, Milord. Because right of recovery is there. And the liability has been apportioned, Milord, between the two insurance companies.
So how much it comes to, Mr. Lal? if it is 36,000 or 40,000, how much it comes to?
Milord, then
Tell me.
after
I have to calculate.
deduction, one third deduction, Milord, it comes to 3,84,000, excluding conventional head.
Yes, Mr. Lal.
Yes, well, that would be calculation would be there, well, if 3 lakhs 3,000 is taken, certainly it is going to it will increase. I'm not I'll not dispute about it. I cannot.
So,
But for
are you willing for a settlement?
Yes, Milord.
well, how much
The
will
the compensation awarded in this case is only 1,64,000.
yes, it is about it needs to be enhanced. But as
Yeah.
per the schedule of now, but well, in that case, there should be a there could be a limit on the basis of rupees 3,000 per month only. Otherwise it will go outside the scope and purview of the 163A. That would be my our difficulty.
So
So
its
if my
maximum is 40,000.
yes,
So maximum is 40,000.
maximum is 40,000. If it is
So
calculated on it is all calculated on that, I think my client may not have any difficulty.
how much? Mr. Karan, are you agreeable if the notional income is enhanced to 40,000?
Yes, Milord. Yes, I am agree.
Yes, Mr. Lal. So
But
how much
my
it comes? You both calculate and tell me.
Mr. Roy, can you calculate? I don't having the, I'm not having the calculator.
It comes to around 4,57,000, Milord, including the conventional head.
4 lakh?
4,57,000.
This 164 has been paid.
164,500 has already been paid.
How much comes total? How much comes? 4 lakh?
4 lakh
57,000.
67. So balance would be 3 lakh 25,000.
Well, we'll seek
Yes,
instruction.
Milord.
I don't think there will be any difficulty with us, but I'll have to seek instruction for my client.
Just a minute, 60. How much it comes to? Oh, 3 lakh. I said 3 lakh. How much?
Milord, if the income taken 3,000 per month,
No,
then it comes to
40,000.
3,84,000.
40,000. 40,000. 40,000 yearly.
Oh, 40,000.
40,000 yearly. Calculate it. 40,000 yearly. How much it comes to?
Milord.
How much it comes to? After the structured formula. Yes.
Milord, 4,26,600.
4,26,600 minus.
Deducting one third, Milord. After deduction one third, it comes to 4,26,000
Plus
plus
add the
conventional head.
how much?
Milord, if we take the structured formula, that is very less, 2,500 plus
No.
500 plus
That,
2000.
that will be as per Pranay Shetty. It will come to 4 lakh
If
96.
we add 70,000, then it comes to 4 lakh
96.
96,600.
4 lakh 96, just a minute. 4 lakh 96 less 1 lakh 74. 1
64.
lakh 64. 3 lakh 31. Yes, Mr. Lal.
Yes, well, we'll seek instruction, my lord. We'll
4
seek
lakhs
instruction.
more lump sum.
How much?
4 lakhs.
4 lakhs more apportioned between the two insurance companies. In the
Yes.
same.
There was apportionment in the order.
Yes.
Yes, my lord.
Yes.
Yes, my lord, it is there, my lord.
4 lakhs more.
Yes, my lord.
Mr. Roy. Switch on, unmute yourself. Yes, Mr. Roy.
Yeah, no, we are ready to compromise. But we need
4
some
lakh
time.
rupees, 4 lakh rupees over and above what has been paid.
Over and above.
Yes, lump sum.
I will say instructions next week.
I'm telling you why. I'm giving you the reasons also. The award is of 16. Now we are in 2022.
Lord.
So 7% interest for 3 years. I have just calculated. So you save some, he also gets some.
We'll seek instruction.
4 lakhs, yes, Mr. Karan, 4 lakhs
Yes,
more.
my lord. Yes, my lord.
That may be recorded and we'll take instruction.
Mr. Karan appearing on behalf of the claimant submits that his client will be satisfied if a amount of rupees 4 lakhs more in lump sum is paid to his client. Let's start. Next paragraph. Considering the said submission, the counsel appearing on behalf of the insurance companies prays for 1 week's time.
Yes, yes.
To seek instruction, full stop. Place this case after 1 week. It will not go to the Lok Adalat because I have to give you the right to recovery amount.
Yes.
It will not go before the Lok Adalat. It
Yes,
will be a
Lord, this will not.
it will be a consent order.
My lord, in this, there one thing I would like to submit, Your Lordship. We are facing some difficulty because the present member secretary is forcing us to refer those matters also in which the right of recovery has been given. So to one of my clients, I have advised that how can you get this thing? Because the right of recovery can be given by the Honorable High Court only, and the Lok Adalat cannot do so.
Yes.
But
You tell them. You tell them. Make him understand.
But the member secretary is not understanding this thing. This is the reason I'm telling you.
Then don't say that I will. We are ready for a compromise.
But then there are several consequences he's taking.
What is
He's writing to the CMDs and all those persons that your officers are not willing to cooperate.
What is this?
This is what we are facing the difficulty. This is the difficulty we are facing. Everybody, we write to the CMD and chairman. He's doing this thing, and he has sent the letters also to them.
Tell the member secretary to come to my office. 1:30. Member secretary Jharkhand. Along with the member secretary of the High Court Legal Aid Services. Both 1:30. Yes.
Serial number 26, MA number 460, Mr. Arvind Kumar Lal for appellate.
My lord. In this case, my lord, since insurance company has not appeared, my lord, I may be allowed to serve 2 sets of copy to Mr. Asutosh Anand, normally appearing for Sriram General Insurance Company.
Where is Ashutosh Anand?
Yes, Your Lordship, I am appearing on his behalf.
You will receive notice. You will receive
Yes, Your
notice.
Lordship.
Ashutosh Anand receives notice on behalf of Sriram General Insurance Company. Limited. That is IE. Respondent number
3, Your Lordship.
3. So no right to recovery granted.
No,
This is for enhancement.
my lord.
Injury case,
So death case.
death case. What is your ground?
My ground is, my lord, that the teacher prospect has not been given. It ought to be 10%. Conventional head only 10,000 has been given, my lord, and the disease was 40 years, but the court has considered it as more than 50 years,
What
as she was
basis?
earning. Uh, it's just presumption, my lord, because all in all my evidence, everybody has said 40 years.
Postmortem report?
Postmortem report is also 40 years. So therefore, my lord, next week let it be taken up along with all the
Where is the
documents I will.
postmortem report? Postmortem report is not an exhibit.
My lord, just a minute, my lord. Postmortem report
Yes,
I have got.
exhibit 10. See exhibit 10. Mr. Lal, see exhibit 10. What is that? What is the age?
45 years it has been mentioned,
So it should be taken as 45 years.
my lord. So therefore, future prospect ought to be 25%, my lord. But if it is taken into consideration 50 years or more, then it will be 10%.
Uh, where is Ashutosh Anand? Just tell him to join.
Your Lordship, he is on decks and other court, Your Lordship.
You serve 2 copies,
My lord.
Sir Vidlal and Ashutosh Anand. And madam, you seek instruction whether your client is ready for a settlement or not.
My lord.
Same
Yes, Your
to
Lordship.
Let it
same
be
as
taken
per
up, my lord.
yes.
Next week, my lord. Let it be taken up next week. If possible, we will settle the matter in National Local Adalot.
5th. List this case on 5th.
My lord.
5th to explore as to whether the dispute can be settled in the National Lok Adalat.
My lord.
Serial number 27, and number 39 of 70, Mr. Ambedkar Sahu, for appellant, Mr. Vikas Kishore Prasad, Mr. Naveen Kumar for respondent.
Yes, Mr.
This
Sahu.
case, इसमें क्या मांगा गया है मिस्टर
Yes.
काउंसिल दिस केस में लिस्टेड फॉर टुमारो लॉर्डशिप
Why?
एलसीआर कॉल फॉर हुआ था लॉर्डशिप तो सीनियर
You have not gone through the NCR. You have not gone through the lower court records. Who are you? 2914. Probate has been dismissed.
Yes, sir.
Tomorrow?
Lords, yes, Lords.
So bring the judgments. Bring the judgment relevant citations.
Yes, Lords.
So the Supreme Court. I hope you
Yes, sir.
understand which decisions you have to bring.
Yes, sir.
Come ready with the decisions. Without the decisions, I will not hear your case. There are decisions in your favor, I am telling you. Yes.
My lords, item number 28, I am appearing for the respondent number 2 and 3. In case that's been called out, there was...
Number 169 of 70, Mr. Ashutosh Anand, Mr. Deepak Gupta for appeal. Ms. Chitra Pandey, for responding.
Your Lordship, in this case, I am praying for short passover, Your Lordship.
What is this case? Tell me first. What is this appeal for?
Your Lordship,
Where is the proof of depositing? Who is for the claimant?
my lords, I am appearing for the claim, two of the claimants, respondent number 2 and respondent number 3. They were initially respondent number 2 and 3. One has been deleted now, so they will be respondent number 1 and 2. My lords, if my lords will permit, I'll just briefly state the case, my lord.
Respondent number 2.
The mother of the deceased and the brother of the deceased.
And 2 brothers of the deceased.
I'm for one brother, my lord.
Where is the other brother?
It's, I don't know. There are other counsels also appearing. I'm not sure if they're representing.
I am for respondent number 5, Your Lordship. Owner.
Deceased was a bachelor.
Yes, ma'am. My lord, I have gone through the payment which has been made, and if we go through the Pranay Society judgment, my lord, the amount comes to same, my lord. Because they are on the point that the so far as the conventional heads, my lord, there's a difference in the conventional head which has been ordered in the judgment, and what is the law as per Pranay Sethi. But if we go for the 40% future prospects, we add to that, and then 77,000 for the conventional heads, my lord, 70,000 plus 7,000 after 3 years, and with the amount will come to the same which has been granted by the learned court below, my lords. That is of 7,57,400, my lord.
What was the age of the deceased?
23 years, my lords, and his my lords, the 18 will be the number on which the compensation has to be counted as per Pranay Sethi again. They have taken it as 16. They can recalculate if they want, but it will come to the same number, my lords.
Let Mr. Ashutosh come pass over.
Yes.
Pass over.
Serial number 29, MA number 353 of 70, Mr. Alokwal for appellant.
Where is Mr. Aloklal?
Yes, Your Lordship.
Yes, what is this?
ये वाला दो ना.
Appeal about?
Well, in this case, I am appearing for the insurance company and we are challenging the liability because the notices were issued. I am not sure whether the status of the notice, because there no name is appearing for the respondents.
On what ground you are challenging your liability?
Yes, I am challenging the liability on one and the only one count, that is, the deceased, he was on the motorcycle of the insured after borrowing it, and accident has taken place on account of his own act of negligence. So the first leg of argument,
where it has been held,
that is the evidence itself, my lord, but evidence is there.
Where is the
Evidence
issue?
is there. FIR is there and evidence is there. And secondly, the motorcycle was insured in the name of Chotelal Munda, and this deceased he was riding on his motorcycle.
Just a minute.
So therefore,
show me that the accident has occurred because of rashness of the deceased.
Because of his own rashness and negligence, the accident has occurred.
Where is that? Where is the issue to that effect?
Because of his own act of rashness and negligence.
This is your submission. I am saying, what is the finding?
Yes,
Is
the
there any
finding is not correct. That is what I am assailing, Your Lordship. Kindly come to.
No. First, whether there was any issue framed.
Issues are there, my lord. Issues.
No, on the point that who is responsible for the accident?
8 issues were framed. 8 issues were framed, and none of the issues was relating to the own act of negligence. The only thing is that whether the vehicle involved in the aforesaid accident was insured with
Call for the lower court records unless this case thereafter.
Serial number 30, MA number 366 of 70, Mr. Ashutosh Kumar Singh, Ms. Chandra Kumari for appellant.
Yes, my lord, I am appearing in this case, my lord.
Yes.
My lord, this case, my lord, is arising out of Succession Act, my lord, whereby my lord, the probate has been refused by the learned court below, my lord. My lord, so far as the case is concerned, my lord, it is being said, my lord, that the will was executed on 30th September 2000 And subsequently, my lord, the executor died on 2/10/2010, my lord. And
2000
after 2 days, my lord.
murdered.
Yes, my lord, he was murdered, in fact. And the appellant, my lord, this petitioner appellant, my lord, he was an accused in that case and he has been convicted in that case. Appeal is pending here in itself. So far as the issue involved in this case, my lord, just I want to submit your lordship, my lord. The matter, my lord, is on the ground of delay, my lord, under section 137 of the, under article 137 of the Limitation Act, my lord. It has been held to be barred by limitation, my lord. And secondly, your lordship, kindly paragraph 24, my lord, of the judgment, my lord, internal page 20 of the judgment, my lord.
What was the relationship between the deceased and this person?
That is, my lord, had not been proved, my lord. Even the witnesses who are there, my lord, with respect to the will, my lord.
No, no. What is your submission?
My lord, the submission is concerned, my lord. The finding is otherwise, my lord. Even the examination in chief of the PW1, the appellant itself, my lord, goes against me, my lord. So for that part is concerned, my lord, I cannot insist.
Wait, what did he say?
My lord, in fact, my lord, he says, my lord, that everything is known to the lawyer. I don't know what is written in my petition on examination in chief, my lord. The note, my lord. Therefore, it becomes very difficult to assist on that line, my lord. Therefore, I am submitting to that one. On the ground of limitation, section 281, my lord, so far as the witness of the will is concerned, my lord, he has not verified, although it is directly, my lord, it's not mandatory. So far as section 281 of the Succession Act is concerned. But, my lord, so far as the evidence of PW1 itself, my lord, it goes against me, my lord. He has not proved any of the contents of the examination in chief, my lord. And that
PW number one is the
PW1 is the appellant, my lord.
uh, who is in custody.
He is now in bail, my lord. After
Oh,
coming,
who's the convict?
he was in a convict, my lord. Kindly see, my lord, paragraph 24 of the judgment, my lord.
Yes, I am in paragraph 24.
Yes, Lord. So kindly see, Lord. It is evident from the evidence of PW1, who is the plaintiff of the case, that he has not filed the certified copy of the voter list of the year 2009 or revision year of 1995. Further, he states that he is not knowing about the contents of the affidavit through which he has filed examination in chief. Rather, his advocate could say about his contents. Further, he states that he could not say whether original will has been filed in this case or not. It is important to note here the examination chief of this witness was taken on affidavit which was in 32 paragraph. And in that very examination chief, in paragraph so and so, this witness had mentioned about the condonation petition under section 5 of the Limitation Act, plain voter list and of the year 2009, will dated 30th September 2000, signature of the witnesses so and so, and respectively about which it has been paid to mark these documents as exhibit. However, the witness himself was unable to prove any of the contents of any of the petition. Rather, he replied he is not aware about the contents of the petition. Lord, under those situations, my lord, it becomes very difficult to proceed, my lord, with respect to any of the argument, my lord, in them. And so far as the limitation point is concerned, your lordship, the issue, my lord, has been decided.
So no original documents were also filed.
That is the difficulty, my lord, so far as the appearance is concerned, my lord, from therein, my lord. Even on ground of limitation, issue number 6 and paragraph 16, my lord. Because so far as the suit is concerned, in view of the judgment given by the Supreme Court, my lord, in 2008 and 2019, my lord, Article 137 is applicable under the Indian Succession Act, my lord.
Yes.
Yes, and therefore, my lord, so far as the delay is concerned, it cannot be condoned, my lord, so far as the original petition is concerned. Section 5 has got application, my lord, only in case, my lord, where the appeal is there or revision is there.
Appeal petition, appeal revision or this.
Original petition, the section 5 has got no application.
Cause of action cannot be extended by limitation act.
Section 5, my lord.
Cause of action, if there is a cause of action,
yes,
and, if a suit is, if a cause of action is barred, if the suit bars a cause of action for filing, then
according to my case, it's about the death is being, so far as the death is being said to be caused in October 2000 itself. Petition has been filed in 2011.
2011.
Lordship, the limitation under Article 137 is, my lord, so far as the date of knowledge is concerned.
3 years.
3 years, my lord.
So and you had knowledge about this will?
Yes, my lord, I had knowledge. There is no pleading, my lord. I am making a prayer for condonation of delay in my petition itself, my lord. In examination in chief, your lordship has seen, my lord, so far paragraph is
No,
concerned.
condemnation of you can say that I didn't have any knowledge. I came
Then, my
covered the knowledge in 2010.
the matter would have been different, my lord. But
It
once
is not the case that
I have admitted that I am making a prayer for condonation of delay. That signifies, my lord, I had knowledge. Therefore, my lord, so far as these two issues are concerned, your lordship can pass order, my lord. I cannot insist upon without recording my submission in this line, my lord.
So definitely.
These are the two important, my lord, so far as the points are concerned. So far as the other facts are concerned, my lord, I am not harping upon that, my lord, because this is the two vital issue, my lord, which is against me, my lord.
And you cannot rectify the same also.
That cannot be rectified, my lord. The mistake which has been committed by the plaintiff, my lord, by while cross-examination is being made, my lord, he has admitted so far as the entire case of the defendant is concerned. I mean, the opposite party is concerned.
Who filed the FIR?
My lord, the daughter, my lord, has filed, my lord, probably. My lord, the wife has filed, my lord.
The wife?
Wife of the deceased. Its case, my lord, there were two wives, my lord, Meera Devi and Phatu
So
Devi.
the deceased was residing
with this appellant, my lord, it is a case of the appellant.
With this appellant is?
My lord, he is claiming himself, my lord, he was looking after, my lord, so far as the deceased is concerned.
PW2 also is the scribe. He also said that I can't say anything.
My lord, PW2, PW3, my lord, they have also not supported, my lord, so far as the case of the plaintiff is concerned.
Who is PW number 3?
PW number 3, my lord, was
witness.
Yes, my lord, he is a witness, my lord.
He says that I am neither a witness nor a identifier.
Witness to the will also, my lord.
He says that I am neither a witness and nor the.
My lord, he has been produced, my lord, and therefore, my lord, and PW4, my lord, you see, my lord, he is the son and he is also not supporting, my lord, so far as the case is concerned. At that time of execution of it, will, my lord, PW4 has said he was not present, my lord. Therefore, on which witness, my lord, I'll argue.
I hope you have received your instructions. I hope you have received your instructions.
Lordship, that, my lord, that I can say, my lord.
Dismissed. Because I have to write a lot. I let not waste the time of the court.
Lordship,
Dismissed.
Lordship.
Senior dismissed.
Serial number 31, MA number 385 of 17, Mr. Mahesh Tiwari, Mr. S.K. Singh, Mr. Abhishek Kumar Dubey for appellant, Mr. Mohammad Asatul Haq, Mr. Virendra Kumar, Mr. Pratish Kumar for respondent.
In this case, my lord, on the instruction of Mr. Sadulak, I am appearing, my lord,
Yes.
for the claimant.
Yes, Mr. Tiwari.
May it please your lordship. In this case, your lordship, we have challenged the judgment wherein the learned court has granted compensation, your lordship, to the tune of rupees 7,68,000, together with the simple interest at the rate of rupees 9%. On the last date, your lordships have been pleased to direct the petitioner to file a supplementary affidavit bringing on record as to what is his status. And we have filed a supplementary affidavit, your lordship, on 10/1/2020. Paragraph 4, your lordship, that it is submitted that in compliance to the order dated 7/12/2021, the present supplementary affidavit is filed by the appellant that
Okay.
as per
Now,
the direct,
what is the ground in your appeal?
the ground, your lordship, is that paragraph 12, 13 and 14.
Yes.
Please just have a look to paragraph 12, 13 and 14. That it is humbly submitted that on the intervention of the village panchayat, the petitioner, the appellant before your lordship, he is the driver come owner of the small minibus, which met with an accident, your lordship, and subsequently it is stated that the husband of the claimant died. Now, your lordship will please see paragraph 12, 13 and 14, that it is humbly submitted that on the intervention of the village panchayat, an amount of rupees 1,70,000 was paid to the opposite party number 1 in presence of villagers on the allegation because of the accident of the said vehicle of the... Yes, your lordship.
Where you are reading this?
Paragraph 12 of my memo of appeal.
No, there is nothing in the judgment.
No, your lordship. But what I want to bring before your lordship is, please just have a look to the order passed in the judgment pronounced in the criminal case.
Where is
For
it?
that occurrence, a criminal case was also lodged, in which your lordship, the wife appeared and she deposed. Now your lordship will please see what she has said. That
Where it
is
has
at page number 21. Page number 21.
no. That has not been brought in evidence. Have you brought this on record in the motor vehicle case?
Yes, your lordship. I have stated that I am going to point out, but please see what has been said in the criminal case. What finding has been given by the learned judge. Please allow me only to point out page number 21.
Yes.
Findings, paragraph 6. During the course of trial, the prosecution has examined only one witness, namely Tolmoy Baski, who is the informant of this case. And she is the claimant also, your lordship. BW1 Talmoy Baski has stated the occurrence took place 1 year before at 7 p.m. At that time, she was at her home and she came to know that her husband got injured, who he had gone to sell pigeon at Singharsi Hatia, and during the course of return, he was dashed by Sri Ganesh bus due to rash and negligent driving by the driver. She has further stated that after accident, her husband was taken to hospital where the case was lodged. She has clearly deposed that she could not identify the driver. She has further stated in her cross-examination that she could say whether the bus was being driven speedily or slowly. She has clearly stated at paragraph 6 of her cross examination that she has compromised the case with the accused and a compromise petition was already filed. Besides the aforesaid evidence, the prosecution has failed to bring any other evidence. This was pronounced, Your Lordship, on 27/11/2015. Thereafter, this judgment, 29th day of April 2017, Your Lordship will please see the relevant portion is at internal page 4 of the judgment, that is page 28, running page 28. What fell from Your Lordship that you have not brought this to the notice of the court, page number 4, and the wife of the deceased has already received rupees 1,70,000 from the respondent number 1 outside of the court on village Salis, and in the said Salis, she admitted and undertook that she would not claim as compensation amount for the death of her husband against respondent number 1, and the respondent number 1 on the intervention of the villagers gave rupees 1,70,000 to Talamai Vaski, wife of the deceased, in presence of the villagers on a humanity ground, although the said deceased died due to alleged accident of the said vehicle of the respondent number 1, and the said Talami Baski, after receiving the said amount from the respondent number 1, admitted before the punches that the said amount of compensation is full and final amount, and the income of the deceased has been mentioned in the claim petition is excessive, illegal, motivated, and as a matter of fact, Talami Baski has deposed in the criminal case related in connection with Amrapada PS case number 64 of
Yes,
the.
Mr. Arvind Lal, you have received 1,70,000.
No, my lord. That is the one thing I will say, my lord. If we go through the grounds of memo of appeal, in one side they are saying that no accident has taken place. Another point that accident has taken place and Videsh Panchayat was there. Even if 1,70,000 was
No,
paid, my
no.
lord, but she has not
Compromise,
said.
I'm not on the compromise. Even if he takes 1 lakh, she takes 1,70,000, she has a right to file a compensation case.
Yes, my lord,
This,
she has got right, but she has not whispered anywhere that she will not claim any motor vehicle claim.
just
Because
tell, just
the
tell me
appellant has
whether,
filed for the evidence, my lord, evidence of the criminal case that is not brought on record in the trial in the MSCT. Not even a single document was filed by the owner of the vehicle, my lord, in the
no,
trial
no,
court.
just tell me whether she has received 1,70,000 or not. Yes or no?
Perhaps he has received, my lord, but actually I have got no info. But she has said in the trial court, my lord, मुझे अभियुक्त से हर्जाना स्वरूप 1,70,000 रुपया पंचायती में मिला था, मुआवजा हेतु इस केस में नहीं की हूँ और साक्षी देना नहीं चाहती. But in the MSCT court, 20,000 rupees had been adjusted, my lord. 22,000 rupees had been adjusted. That is in para 14 of the impugned judgment, my lord.
No, no.
Page 14.
If she states that she has received 1,20,000, the same has 1,70,000, the same has to be taken note of.
Yes, my lord. But she has got every right to make claim under the Motor Vehicle Act, my lord.
Absolutely, absolutely, she has every right.
My lord.
There is no doubt about it.
Yes, my lord.
What was the age of the deceased?
Age was 35 years.
Huh?
35 years.
35 years.
That is in para 17 of the judgment, my lord. It has been mentioned. 35 years.
This is leaving behind how many dependents?
My lord. Two.
Two.
My lord. 1/3.
So 1/3.
Although rupees 25,000 rupees has been given as original expenses and 1 lakh for loss of consortium, my lord, but no future prospect has been given.
Yes, that I've seen. Yes, yeah. Yes, Mr. Mahesh Tiwari.
Yes, Your Lordship.
Is there any chance of settlement?
Yes, Your Lordship. She was in touch with the present appellant, and now, Your Lordship, subsequently, as I am told, she has solemnized marriage, another marriage, Your Lordship, with
That is
no,
significant.
and then now for the last 10 days, Your Lordship, she is not there. Because I had told the appellant also that if there is any chances of compromise, the matter may be settled. And on the last date, he has said,
My lord.
Mr. Any chance of settlement?
Yes, my lord. Every possibilities are there.
Just tell me.
And I'll let it be referred to.
Because Mr. Arvindal, there are two things. She is not stopped from filing an claim application.
My lord.
She has a right to file a claim application. Number one. Number two, this amount of rupees 1,70,000 which she has received needs to be adjusted.
Yes, my lord. No doubt.
So both the parties, I'm keeping it on 5th.
On 5th.
5th.
Okay, my lord.
From the submission of the parties, this court feels that there is a chance of settlement between the parties. First up, place this case on 5th to explore whether the matter can be referred to the Lok Adalat or not.
Serial number 32, MA number 559 of 17, Mr. Arvind Kumar Lal for appellant, Ms. Rishi Bharti, Mr. S. J. Roy, Mr. Alok Lal, Mr. Ajay Kumar Singh for respondent.
In this case, my lord, on previous occasion, the matter was referred to Lok Adalat for settlement, my lord. But since it is a case of collision of two vehicles, only one insurance company appeared, my lord, and another insurance company not appeared, my lord. Therefore, it was not settled, my lord, on that day. Because liability has been fixed upon both the insurance companies. Therefore, this time, if the both insurance companies will come, I'm ready to settle.
Right to recovery granted or not?
No.
Yes,
No
Lord.
right.
Right to recovery has been granted.
To whom? Okay. But
National Insurance Company.
I am appearing on behalf of United India
Respondent
Insurance.
number 4. Right to recover from respondent number 4.
yes, my lord. I'm sorry.
Who is respondent number 2? Without a driving license.
The vehicle.
Who is OP number 2? Who is appearing for OP number 2? Who is appearing for OP number 2?
I'm not aware, my lord.
OP number 2 appeared before the tribunal also.
Yes, my lord.
Had OP number 2 appeared before the tribunal?
He was represented by one Sri Ramayan Kumar advocate. That is in the mentioned in the judgment itself, page 2. He was duly represented.
So where is
His
OP
lawyer's
number
name.
2? What about the notice of OP number 2?
He has also filed written statement in the court below.
Respondent 1 to 4 appeared through Wakalatnama. Check who is appearing for OP number 2. What is the name of respondent number 2?
Vikas Singh.
I see.
Singh.
Vikas Kumar Singh.
Lawrence J. Roy. Yes. Ajay Kumar Singh. Satendra Kumar Singh. So this, since there's a right to recovery, the matter cannot be referred to the Lok Adalat. Lok Adalat cannot pass an order.
Then if the respondent 2 has not appeared, my lord, let a fresh notice be issued.
Respondent 2 has appeared.
Oh.
Now he has to accept the right to recover the amount. Lok Adalat, there has to be an acceptance from his
Very
side
correct.
also that
Yes,
is agreeing to pay the amount to the insurance company. Otherwise, I pass an order.
Yes, madam. Then let me inquire, my lord, whether respondent 2 has filed any appeal.
In the case of permanent disability,
Yes, my lord, 50%.
so how much was your expectation in the last Lok Adalat?
In this case, my
What
lord,
was
I
your
have
order?
inquired from my client, my lord, on last occasion, my lord. He is a villager, my lord, and he was earlier selling vegetables in wholesale market. Now he's saying that if 2,50,000 or 3 lakh will be given to him, he'll be satisfied.
Who are the other two insurance company?
Bajaj and United India.
Yes.
Saying on behalf of respondent number 4, United India Insurance Company.
No. The tribunal has granted how much? What is the award? 2 lakh.
2,08,000.
2,08,920.
Liability has been fixed 50-50.
Yes, that I've seen. Yes, he's claiming 2.5 to 3.
But there was no document filed regarding to his injury. No medical certificate was filed.
All certificates are there, my lord.
Admitted in RIMS.
Page 4 of the judgment notion. But from the appraisal of the entire record, I found no any medical certificate to the original copy has been filed by the applicant on record regarding permanent disability as claimed.
Exhibit 4, discharge sheet 5259. Registration ticket in original copy issued by ZIMS. Exhibit 6 to 6 by 37, original copy of bills, invoices, etc. Investigation report.
So you both the parties you can sit and you can decide.
My lord.
Who is for the owner? Oh, but the owner, they're not appearing. Mr. Roy and Mr. Uh, what is your name?
Santosh Kumar.
Santosh Kumar,
Santosh.
Lordship.
You contact your insurance company and give an offer, or if you accept this offer
My lord.
on behalf of the respondent, no one is appearing, so the right to recover. Yes, this is on 5th to explore whether there is any chance for
Mr. Lal is asking for 2 lakhs more.
2.5. Between 2.5 and 3. Now, what will be the amount on settlement? I am not know. It is not known. Subject to both sides' satisfaction.
okay on 5th
We'll see. Lordship.
on the hearing for orders.
Obliged, Lordship.
Did they explore his sub on the hearing for orders?
Serial number 33, MA number 736 of 70. Mr.
This
S.
claim for compensation case has been filed, my lord, under Workmen Compensation Act, my lord. And my lord, the deceased is the son of the appellants, my lord. That was dismissed. Lordship. He was a khalasi in the truck of the employer, that is opposite party respondent number 1. And respondent number 2 is the insurance company, my lord. The claim for compensation case was earlier filed in the year 2011. Paragraph number 19 may be seen, my lord, of the judgment, of the award. 19 of the award, page 36. Para 19, I'm reading, my lord.
Yes.
In order to appreciate the issue of limitation, on the ground of limitation, it has been dismissed. Now, in order to appreciate the issue of limitation in the light of a post observation, let us turn to the pleading and evidence by which relief for condemnation of delay was sought. On this score, a petition under Section 5 of Section 14 of India Limitation Act has been filed by the applicant. It was stated therein that one another claim case has been filed on 13/4/2011 by the applicant bearing TMV claim case number 9411 before the Motor Accident Claim Tribunal, Dhanbad, under Section 166 MB Act. But on account of non-payment of the court fee, such case was dismissed on 22/7/2013. It was released at the meanwhile from 8/11/2014 to 5/4/2015. Applicant Samsudin fell ill and suffered by cold, cough, and anemia. Because this reason he could not be able to come down to night, and therefore
Unmute, Mr. Secretary, unmute yourself. Unmute.
Unmute हो गया आपकी है क्या?
Yes.
Therefore, on this ground, my lord, on the ground of limitation, it has been dismissed, my lord. That undisputedly, in page number 37, undisputedly accident took place on 14/15/11/2010. An instant case has been filed on 23/11/2015, that is 5 years from the date of accident. Proof the defense taken by the applicant for condemnation of delay no sheet of paper has been filed by the applicant. On the ground of this, my lord, on the ground of limitation, severally medical prescriptions was also not filed in the original. So keeping in view this limitation period, this case has been under Workmen Compensation Act has been dismissed.
What is wrong?
So earlier he had filed, my lord, in their 2011, but Samsudin fell ill, my lord.
What he filed? Employees compensation.
He had filed, my lord, under title TMV under Section 166 MB Act, my lord. And that case was dismissed on 22/7/2013. So thereafter,
no document was filed.
Thereafter, he filed a phrase, my lord, this under Workmen Compensation Act.
No document was filed.
But this point is taken into consideration. So
then
it is to be seen from the, my lord, from the exhibits whether it is any file or not, my lord.
The court says it has not been filed.
May I submit one?
SCR
Yes,
This
yes.
plea of limitation is not tenable, my lords. Though they have not filed the documents, but they had filed the case, I have verified from the lower court record. But the
Verified.
second point, paragraph 20 is most relevant, my lords. Under the claim under Workmen Compensation Act, my lords, there has to be relationship between employee and employer.
Yes.
That itself is missing in this case. The father of the deceased, who is claimant before your lordship, he himself has admitted that employer was somebody else. But case has been filed against this employer and he has denied that the deceased was his employee.
But the witnesses,
The main ground, my lord, that should have been taken for dismissal of the appeal. This limitation, my lord, although they have not filed the documents, but the fact remains I have verified from the my lord's website of the e-court, my lords. This miscellaneous appeal number, MV claim case number 9411 was filed indeed. So limitation is not valid ground, my lords, in my humble submission. But so far as this issue is concerned,
but all the witnesses are so far the relationship is concerned.
LCR may be called for, my lord, because evidence will be required to hear.
All the witnesses have said that
The ground which the one of the ground for dismissing the claim application under the Employees Compensation Act is that the claimant has failed to prove the employer-employee relationship between the deceased and
insured.
The insured. That is respondent number 1 here. To appreciate next part, to appreciate the aforesaid finding, it is necessary to go through the lower courts. Call for the lower court records.
obliged.
Serial number 34, MA number 753 of 70, Mr. Alok Lal for appellant, Mr. Vinod Kumar Singh, Mr. Rajendra Ram Lohidas for responding.
But in this case, I am challenging the liability on the ground that the driver was having a forged and fabricated driving license. But my contention, in spite of bringing on record and evidence, has not been acted upon, but the liability has been fixed upon the insurance company. And after the passing of the award, we filed a review application, and review was pending during the pending. Thereafter, we could not file an appeal. After the disposal of the review, we have filed this appeal. Therefore, the delay was there, and delay has been condoned by your lordship. So now, in this case, my lord, it would be subject to lordship's consideration. In my opinion, it would be the LCR would be necessary in this case, because documents we have filed that has been incorrectly been appreciated by the tribunal. And in
my lord, I am
in
representing respondent number 1 to 5, my lord.
You are the claimant.
For the claimant, your lordship. Your lordship, rightly the court below has passed the order, your lordship, because at para 8, your lordship, of the judgment, your lordship, it has been clearly mentioned by the court below, your lordship, that it is pertinent to mention here that no oral evidence has been adduced on behalf of OP number 2, New India Assurance Company Limited, to show that the deceased met with the accident due to his own negligence, as he did not follow the traffic rules, as there was any violation of the term and condition of insurance policy.
Considering the argument advanced by the parties, it is necessary to go through the lower court records. Call for the lower court records.
But we have paid rupees 2 lakhs in terms of 106 to 18.
Yes, my lord, they have paid, your lords.
Yes.
Serial number 35 and serial number 36, MA number 130 of 19 with cross objection 30 of 21. Ms. Manju Pandey for appellant in first case, Ms. Olga Kumari for appellant in second case.
My lord, I am on behalf of the appellant, and my lord, I have obtained the copy, a certified copy of application filed by the claimant in the lower court. My lord, kindly see at the page of application in para 8, where it is clearly where it is clearly stated that that the address of the place of occurrence is given, but date of accident is not given, and the same is
You are the
I'm on behalf of appellant in para 8 kindly see.
date of accident has not been given. Mention.
Again, my lord.
You are the owner of the vehicle. You represent the owner of the vehicle.
Yes, my lord.
And the next one is for enhancements.
Again, my lord.
The vehicle was not insured.
No, my lord. My
The
lord,
vehicle was not insured.
I have stated, I have submitted already on the previous date also, that kindly call for the record and kindly see that the trial in the lower court below, nothing is, everything is irregular in the during the trial. Even at even you can see in the record that the witness has stated once. Witness is saying that the so and so on the same so and so date accident occurs, but again during cross examination, same witness said that they know nothing about it. They completely deny and they admit the ignorance of the date of accident. So my submission is that if the date of accident is not clear, how the case is revolving around the liability to pay the compensation. First thing. Secondly, I had stated earlier also that this judgment is based on FIR, charge sheet, and doctor's report, etc. But neither FIR or charge sheet or any doctor's report is given to the appellant. She is quite ignorant of the fact that any FIR was lodged, any charge sheet was given. She was completely ignorant, and she after the service of notice, she came to the court, and there she stated whatever was she was told by the advocate to tell. But she is not, she is completely ignorant of the fact that any FIR was lodged against her. In fact, I don't have a case record, and I don't have a FIR or large sheet also, charge sheet also. But as per the judgment, it becomes clear that the FIR was lodged by one of the witness, not by the claimant or any family members of the claimant.
Not necessary. It is absolutely not necessary that the FIR should be lodged by the claimant or any other family member of the claimants. Any person can lodge this FIR.
Yes, but she could not given chance to explain what happens and how she is ignorant of the fact and whether she is liable to pay the same, because as per the judgment, it shows that it so happens according to the witness that the tractor was loaded with chips, and it was according to the witness, it was and witness are not independent, they are all interested witness. They have
read the FIR.
Sorry, Your Lordship, I don't have FIR, and the appellant had also not given any FIR or charge sheet. copy of charge.
This case.
That's why I prayed for.
List this case on 2nd of May on a physical day. I'm keeping it on a physical day. List this case on 2nd of May. Well, this case will be heard physically.
Your Lordship, it may be clear that no further adjournment will be taken on another one and another ground for adjournment is taken on behalf of appellant. Petitioner claimant is suffering from 2014. Not a single penny has been given to her.
There is no stay. Execute the award. Hearing cases second half. Just a minute. There's a Passover matter. For the Passover cases.
Number 95/60, Mr. Yudhit Sinha, Mr. Suraj Singh, Mr. Ullas Sinha for appellate, Mr. Nikhil Ranjan for respondent.
My lords, in this case, my lords may see the last order. Pursuant to that, we have deposited the cost of ₹5,000 with the counsel of the claimant. And a supplementary affidavit is also filed by. The IA is for condonation of delay.
This IA is for condonation of delay. Who is appearing?
Your Lordship, I am appearing for the claimant's respondent, Lord.
There is delay of 90 days, my lord. I have brought on record the entire file movement just to show the bona fide on our part. The entire decretal amount, since it's an appeal arising out of Employees Compensation Act, is already deposited with the Employees Compensation Commission. Some delay has occurred due to the movement of the file with the different authorities. And once the demand draft is prepared, my lords, within the sorted process.
Imputed judgment was passed on 9/9/2015.
Yes, ma'am.
The application for certified copy was paid on 15/9. It was received on 16/9. First note was prepared after 2 months.
Yes, that is there, my lords. Whatever is there, I have brought on record. This is the file movement, what I asked them to submit. And this has come to me. The proposal, the movement up to GM personnel, DGM, AGM, their approval, then, my lords, the consent for preparation of demand draft that was given sometime on 9/2/2016. Then the file was handed over, and my lords, on 17/2/2016, this appeal was filed. We have filed this appeal within 6 working days from the date of receipt of file.
That is your office.
Yes, I am just trying to show bona fide. And my lords, there is a substantial question of law involved in this case, because it's an appeal in terms of Employees Compensation Act, and there has to be substantial question.
What is the substantial question of law?
The substantial question of law, my lords, that there is an NJS agreement. The agreement between the steel company workers and the Ministry of Steel. Pursuant to this.
It's called NJCS.
NJCS, I am sorry. NJCS. Pursuant to this agreement, there are circulars. Those circulars confine the theory of notional extension. Those circulars says that if quarter is allotted to an employee, then from the allotted quarter to the workplace, 1 hour will be considered as notional extension of time, subject to condition, the shortest possible route.
Let us condone the delay, Mr. Nikhil Ranjan.
My lord, for that, my lord, I have filed the reply and I have annexed the order of Honorable Division Bench of this Honorable Court, in which your Lordship was also. My lord, that reply is there, my lord. The judgment of Honorable Division Bench is there, in which clearly the Honorable Supreme Court.
Sitting with the Chief Justice.
My lord, Chief Justice, my lord.
That is on the particular facts of this case.
my lord, 38 days delay in
That is on the particular facts of this case.
my lord, only thing I would say, my lord, state of UP versus Amarnath Yadav reported in 2014 to SCC 422, which was referred in that case, that moving of file from one department to another is not sufficient cause to condone the delay. That is the only thing, my lord. The rest.
But the concept of the appellate and another concept of the state. There is how many days delay?
My lords, 90 days, 90.
In filing this appeal. First step. We heard the counsel for the parties. The this application is opposed by the claimants. First up, after going through the application, especially from paragraph 4 to paragraph 10, I find that sufficient cause has been shown to condone the delay. Delay condoned. Is this case under the hearing for admission?
My lords, in this case, LCR may be called.
All for the lower court records.
Obliged.
Another pass over.
Serial number 28, MA number 169 Mr. Ashutosh Anand, Mr. Deepak Banerjee for appellate, Ms. Chitra Pandey, Ms. Vandana Singh for respondent.
Yes, Lordship. Lordship, in this case, the insurance company is the appellant. We have challenged the liability as well as the quantum both, my lords. And the Lordship, pursuant to the order, Lordship, we have already deposited 3.5 lakhs, my lords. Lordship, so far as quantum liability is concerned, if Lordship will kindly permit me to place internal page number 17 of the award.
Yes.
The second paragraph, he has also identified the photocopy of driving license bearing number so-and-so of the driver so-and-so, which has been marked as white. For reason, he has also admitted so-and-so. During cross-examination made on behalf of OP number 1 and 2, he has stated that he has deposed a note on the direction of Tata AIG so-and-so, and he has no personal knowledge about this case. He has stated that he has no knowledge that he is so-and-so, but sent which letter to DQ and has not filed before this court, and said that letter has sent for verification of DL. He has stated that on the basis of Exhibit D that driving license of so-and-so is fake. On the basis of Exhibit D, driving license of the driver is fake. He has also said that after getting Exhibit D, insurance company has not inquired about the driving license of Rajesh Kumar Mishra and Pitpuri Karmali, and which driving license is fake one. He has denied the assertion that he is giving false evidence. During cross-examination made on behalf of the claimant, he has stated that in investigation it is part of the investigator to meet charge-sheeted driver. He has further stated that DQ Ranchi has sent his reply to RTI to Santosh Kumar investigator, and thereafter said Santosh Kumar had sent Exhibit D to the legal manager office of the Tata AIG so-and-so. He has further stated that insurance company has sent letter to the owner of the offending vehicle in one time. He has further stated that he has no personal knowledge about driving license.
How about you saying that it is forged?
On the basis of Exhibit D.
LCR is here.
No, my LCR is not called for. The last paragraph, therefore, it would appear that driving license of the driver is disputed and is not valid. The tribunal has rendered a finding in my favor.
Then right to recovery granted?
No, my lord.
So, who is going to claim it? Who owner of the vehicle?
My lords, I am appearing for the respondent number 2 and 3.
So far as the quantum is concerned, Mr. Ashutosh Anand, if...
My lord, quantum is challenged, my lord, if you also kindly permit me to place page number 20.
Yes.
3,25,000 has been granted against 70,000.
What about the future prospects?
My lord, deduction is 1/4. This should be 50% because the siblings are the major brothers, and so this should be excluded, my lord. And the interest, my lord, interest which has been leveled at page number 21. These are 9% with single interest, my lord. This, in my humble submission, should be 7.5%, my lord.
My lords, the multiplier should be 18, my lords, and the future prospect has to be added, my lords. My lords, overall, it will not make much of a difference, my lords.
Multiplier should be 18?
Yes, my lord, as per national insurance versus Pranay safety.
The
23 years, my lord. 23 years, 50% deduction, my lord. There will be substantial change, my lord.
18 it will be, and then my lords, overall, my lords, if we calculate 40% as the as the future prospect, and my lords, 18 as multiplier, then it will come to 7,57,400. But then he is again disputing something else as well, because he is saying 1/4 the deduction. He's going to 50% should be the deduction he's saying. But then I'll have to look into that part, my lords. I'm disputing that, my lords. The deduction should be only 1/4.
Why? All the major,
I'll
they're not dependent.
yes, that I'll have to look into that part.
It comes to 5,23,000, madam.
The age of the respondent number 3, my lords, I'll have to just.
He should be treated to be the dependent of the father.
My lord.
Malus, in any case, the father is also, he was a party and then he's already died. So these are all dependents on him and the legal heirs.
No. Maybe heirs, but not dependent. It comes to 5,23,000.
5,23,000. Malus, I'll check then, Malus. If that is the case, I'll just check because I checked it with 1/4 deduction. Sorry, the 1/4 deduction, 25%. So that is how I was calculating. It was coming to 7,57,400, along with 40% future prospect and 77,000 as the conventional head, my lords. And then again, the interest part, my lords, I am disputing that also. He's saying 7.5%, my lords. So 9% is appropriate, my lords. All these years, my lords, they have been suffering. The mother is suffering, my lords. She was dependent on him. He was an earning member, my lords. Now the father is also not there.
Listen to me.
Yes.
This 3 and 4 cannot be said to be dependent.
3 and 4, I'll have to just check that, my lords. I'm not prepared on that point. I'll have to just check the age and how they're. In that case, what will be the consequences? I'll just check once. So far as, my lord, the other issue he's raising, my lord, so that if he gets the right to recovery, that should be fine. So I'll just check this one point with respect to the dependent, my lord.
Yes, madam.
Yes, Your Lordship.
Yes.
Liberty has been given to recover the amount in question.
Where is that?
Page 29, Your Lordship. Paragraph 45, last portion.
Paragraph 45, last portion.
Page 29, Your Lordship. Accordingly, the OP such and such, in the name of the claimants, with liberty to recover the amount in question from OP number 1 and 2.
Yes, Mr. Ashutosh. Right to recovery granted. It is only the quantum.
Yes, only quantum.
So you pay the amount to the insurance company, madam.
My lord, we decide to speak, my lord.
Yes, claimant, how much?
My lord, I'll just check that part, my lord. The dependence, then how the calculation will go. I'm just stuck on that point, my lord.
Check it. Come at 2:15.
I'll just, yes.
Come at 2:15. Check it.
Must let it be tomorrow, Your Lordship?
Tomorrow, why 2?